Welcome aboard, applicants. Let's finish our part 2 of our general bar exam review. In real property, which is the one that we're on right now, we start with, let's lay out our shopping list first. We go with adverse possession, then we talk about land sale contracts, and then we talk about landlord-tenant situations. We then talk about co-tenancy. Then we talk about easements, licenses, and profits. Then we talk about covenants and equitable servitudes. Make sure to put that in there. And then 7, we talk about present and future interests. And then we finish up with miscellaneous. Now, under adverse possession, we're going to talk about whether or not the adverse possession was continuous. Then we talk about whether or not that adverse possession was hostile. Then we talk about whether or not it was open and notorious, meaning that it was known. And then we talk about whether or not it was actual adverse possession and exclusive adverse possession. We also want to make sure that we talk about if this is applicable, tacking and tolling due to disability. Now, after talking about adverse possession, we now go down to landlord-tenant, or excuse me, land sale. Excuse me. In land sale, we're going to be talking about the statute of frauds, basically contract formation statute of frauds. Then we're going to be coming down and talking about the merger clause, so just M. Okay, and then equitables. Let's see. Let me talk about the deed here, and then we're going to. Well, let's see. Equitable. I'll have to hold off on that last word. I know what it means. Is the term right now escapes me. I believe it's equitable conversion. That's right. And then the next one is deeds. And then we talk about after deeds. There's what kind of deed we're dealing with, because there's really only 2. There's quitclaim, or 3, excuse me. Quitclaim, general warranty deed, a general deed, and then there's a special or statutory deed. Now, under here, after talk about deeds, we then want to talk about the recording acts, and this is where we're going to talk about race notice and race notice statutes. Okay, and that should be all for the land sale contract, even though there's actually, wait a minute, right up here probably after we talk about the contract formation, we want to talk about mortgages. So mortgages and loans to secure the sale of the land. So I'll put that in there. And then now under landlord tenant, we want to talk about the type of tenancy that we're dealing with here. Are we dealing with a tenancy for years? Are we dealing with an at-will tenancy? Are we dealing with a periodic tenancy? Are we dealing with a tenancy by sufferance? Okay, and those mainly are the ones that we would be looking at here, and mainly paying attention to something called notice. So as to these, okay, now after the type of tenancy has been established, we want to make sure to establish what are the rights and put in here rights and duties of the landlord and of the tenant. And then we want to make sure to talk about whether or not there's a termination of the tenancy. I'll just put down the T on that one, and then after, yeah, that'll fill out for this for right now. Now under covenants, or excuse me, co-tenancies, we got joint tenancy, or type of co-tenancy. Then we've talked about rights and duties again. After rights and duties, we talk about, oh, excuse me, I should say that we talk about severance, and then termination of the co-tenancy. Now, down under easements, I want to talk about the creation of the easement, the type, or excuse me, the type of easements. Thank you. Type of easement, creation of the easement. After the creation of the easement has been talked about, we talk about the scope of the easement, and then we talk about whether or not the easement has been terminated, termination of the easement. And then we also want to make sure to talk about, if it's applicable, profits and licenses. Now, after that, we were going to talk about covenants and equitable servitudes. In covenants and equitable servitudes, we're going to talk about the the covenants here, which we're talking about writing, intent, touch and concern, privity, which we're talking about vertical and horizontal, see here, thank you, and notice. And remember, there's actual, inquiry, and record notice or constructive notice. Now, after establishing that, and we also want to make sure that we're not dealing with an equitable servitude, so we'll throw that in there. Now, present, future interest. Present interest we're dealing with right to convey. We also are dealing with sizen and against encumbrances. Okay, now those are the present interest. The future interest now would be quiet enjoyment, warranting, okay, and then further assurances. Okay, those are the general present, future interests. This would be for excuse me. Let me redo that, because this is, I just gave you the general warranty deed situation here. So let me redo this here. Let me undo that. Okay, well, this would be, we're talking about fee simple absolute as a fee, the feasible fee. We're talking about a life estate. After a life estate, we're going to be talking about a leasehold, and I believe that's it right there. Okay. Oh, and then future interest. Future interest for these, we're talking about in terms of fee simple absolute, no future interest. A defeasible fee, if we're talking about a fee simple determinable, we're talking about a possibility of reverter. If we're talking about a fee simple subject to a condition subsequent, we're talking about the right of reentry. If we're talking about a fee simple subject to executory interest, we're talking about a third party interest, which would be springing or a shifting executory interest. And those would be the forms of future interest that we would have. And remember too that we would have reversion interests for vesting and vesting interest concerning the remainders. Okay, so keep that in mind for life estates. So okay, now that's in a nutshell present, future interest. Under miscellaneous, we're going to be talking about like nuisance. We're going to be talking about trespass to land. We're going to be talking about mainly though. Oh, excuse me. Let me come back here. Bring this up here. We're going to be talking about lateral and subjacent support, nuisance, trespass to land, and water rights. There we go. Okay. I believe that's it for real property. This will be filled out a little bit later, but right now this is good to go. So let's go right now to evidence. Okay, let's actually thank you for your patience with me. There we go. Okay, evidence. We're talking about first thing, relevancy. In relevancy, we're talking about logical relevancy, legal relevancy, and limited admissibility. Now, after that, we're going to be talking about character evidence. And this is where we're going to be bringing up reoccurring patterns of circumstantial evidence. Okay, and in here we're going to be talking specifically about other issues that would be possibly there. We talked about character evidence, habit, similar happenings, and well, I talked about public policy exclusions. Okay, and so there's our list here, and then after character evidence, we're going to be talking about direct examination. In direct examination, there's going to be just making sure that what is being talked about is relevant, and that'll actually set the stage here for cross-examination as well. So when we get down to this here, we got cross-examination and impeachment. There we go. And in here, we're going to be making sure to talk about that when we're talking about impeachment, we're talking about three particular things. We're going to be talking about we're talking about honesty. We're talking possibly about I said three. I have to change that. There's a few of them. So honesty and veracity, bias, prior inconsistent statement. We're going to be talking about a character witness, and concerning defects, sensory defects. So defects in sensory perception. There we go. And then down after that, we're going to be talking about the other thing too about cross-examination. Remember, keeping it within the scope of direct examination, and all this does tie into character evidence, which is very interesting as well. After this, now we're going to be talking about the burdens and presumptions, which we're going to be talking into, like reasonable, beyond a reasonable doubt, clear and convincing, and preponderance of the evidence. Okay, and now after here, we're going to be talking about the type of evidence. Okay, and in type of evidence, we're going to be talking about demonstrative evidence, scientific evidence, and documentary evidence. So we're going to bring that up. Now, after that, we're going to, oh, wait a minute, yeah, okay, yeah, that's right. Opinion testimony at this point, we're going to be talking about expert opinion and lay opinion. After that, we're going to be talking about judicial notice and hearsay exceptions. After hearsay and hearsay exception, which are, we got exemption, exclusion, and exception. And then after that, we're going to be talking about privileges, and that would be like attorney-client privilege, doctor-patient privilege, psychologist-patient privilege, etc. And don't forget about the priest-penitent privilege as well as that. Okay, so just put some space between these here. And there's that. Should have. Oh, thank you for your patience on that. There we go. And there we go. That's evidence for you in a nutshell. Now, coming down to constitutional law, we're dealing with justiciability, which is a nice way of saying standing. And remember, standing can take individual standing, third-party standing, organizational standing, and taxpayer standing. So, but remember, actually, you know what? I went too far there. This is case or controversy. Case and controversy. Let's see. Oh yeah, there we go. See, there we go. And then standing. Individual standing, third-party standing, organizational standing, and taxpayer standing. That's the next one. Thank you for your patience with me. There's the 11th Amendment, Oh, you know what? Before the 11th amendment, thank you so much again for your patience. There it is. Ripeness and mootness, which we talked about. And remember, mootness has an exception, which is topics that are capable of repetition yet evading review. So we want to make sure to talk about that. M has mootness has an exception. So we'll just throw that just like that. Okay. 11th Amendment, and then we want to sort of talk about state action requirement. There's either state action straight up, or there's a traditional function that a third party is a traditional public function that the third party is acting for the government in. So traditional function or significant government involvement. There we go. There we go. And now after establishing these, we're going to be going right into government powers, which would be the judiciary, the executive, and the congressional powers. Now the state powers would rest within the 11th Amendment here. And now with limitations on state power, this is where a lot of the issues are going to lie. And now we're going to be talking about the Supremacy Clause, the Dormant Commerce Clause, the Contract Clause, privileges and immunities. There we go. And the Contract Clause. There we go. Now, after that, we're going to be talking about individual rights, okay, at this point. And we're going to be bringing up, oh, let me right here. Sorry, thank you for your patience. Our acronym here. Excellent. And we're dealing primarily with speech. We're going to be talking about content-based, which we're going to be looking into whether we're dealing with strict scrutiny or non-protected speech. Okay. Now, content neutral speech, we're going to be looking at whether we're dealing in we're going to be looking at the third, our time, place, and manner regulation, and that's it for that. And then want to make sure that we're not forgetting to talk about commercial speech and symbolic conduct. After that, we're going to be oh, wait a minute. Okay, yeah. Okay, so there we go. I think that's actually, wait, I'm sorry here. There's limitations though too, so I want to make sure to talk about the limitations of vagueness, overbroadness, and unfettered discretion, and then prior restraint. There we are. Excellent. Okay. Now after that, we're talking about the press. And then we're talking about the association, which has strict scrutiny aspect to it. And then the religion, freedom of religion, which actually breaks into, let me copy and paste this over here. Thank you for your patience. There we go. Which breaks into freedom of expression and establishment clause. Under freedom of expression, we're going to be talking about whether or not the exception of law of general applicability. Okay, and under establishment clause, we're going to be talking about whether or not there's a sect preference versus no sect preference. So no sect preference, and make sure under no sect preference that we're dealing with the Lemon test. There we go. Now, coming over to takings clause, we talk about taking, public purpose. Let me keep that to just public purpose and just compensation. Now, after talking about taking here, we're going to be talking about the equal protection. Equal protection, we're going to be talking about whether or not it was an intentional or incidental discrimination. And because that'll set the stage later for whether or not we have heightened or intermediate scrutiny. Or I should say strict scrutiny or heightened scrutiny. Now after that, we're going to be talking about the classifications. And this is where we're going to be talking about suspect classification, quasi-suspect classification, and non-suspect classification. Suspect classification receives strict scrutiny. Quasi-suspect classification, intermediate scrutiny. And non-suspect classification is rational basis. Make sure not to forget about fundamental rights, which receives a strict scrutiny. Okay, and let's see. After this, I think this is it right here. Now we go right into due process, which has two components. We've got procedural due process and let's see here. Let me bring this down to the next page here. There we go. Procedural due process, and actually, you know what? Let's talk about the first one. So, substantive due process and procedural due process. Up here at this one, we're talking about fundamental rights and non-fundamental rights. Here, with fundamental rights, we're going to be dealing with strict scrutiny, and non-fundamental rights, this would be rational basis. Now, down here under procedural due process, we're going to be talking about whether there's life, liberty, property interest, mainly property and liberty and property. Make sure to put that in there. And then after that, we're going to be talking about the process that's due. And the process that's due, we're going to be looking at three particular things. So process due, we're going to be talking about the interest, the risk of error, and the government interest. So we got the personal interest, there we go, and got the risk of error, which I think we'll just call just R here, so I can bring that together up here. And then the government interest are all going to be balanced. Okay. And this would be for a non-judicial, so judicial proceeding, non-judicial proceedings, and this would be where this would fit under. So there we go. I don't think that's going to fit too well. I'll just do that. Now, after that, I think we got, in a nutshell, constitutional law. We'll just continue rolling through here. Excellent review. And I'll just make sure I'm spacing all this out so that we can add more later as we modify and improve. Okay, now coming down to civil procedure. I want to make sure to put on our list first subject matter jurisdiction, personal jurisdiction, supplemental jurisdiction. After that, we're going to be talking about notice and service of process, and then choice of law. After choice of law, we're going to be talking about pleadings, joinder, and not to forget discovery, disclosure, or disclosure, discovery. Thank you for your patience. And then after that, we're going to be talking about disposition without a trial. Right here, without disposition without trial. And then we're going to be talking about trial. Bringing this down to the next page so we can put this all on one page here. Excellent. Post-trial, appeals, and after that, doctrine of former adjudication. Now, underneath subject matter jurisdiction, we're going to be talking about federal question jurisdiction. We talked about diversity jurisdiction. We talked about diversity, complete diversity, and the amount in controversy. And then we also want to talk about two other subject matter jurisdiction that we would have let's see here, make sure. Okay, there. Oh, there. Removal and remand. Okay. Now, and then we talk about personal jurisdiction. We're going to be talking about traditional basis. We're going to be talking about the long arm statute. Oh, yeah. And then we're talking about minimum contacts, which involves looking at purposeful availment, foreseeability, relatedness. This is where we get the general versus specific contacts. General meaning that it's just remember systematic and continuous. So systematic and continuous here. There we go. Oh, wait a minute. Yeah, sorry. Let me come back and talk about this. So it's systematic and continuous versus substantial contacts. Okay, that'd be the relatedness. After that, we're going to be talking about the interest of the forum state, and then I believe, oh yeah, we talk about possibility of transfer, and oh, this is where, oh yeah, didn't want to forget this either. I want to make sure to bring up venue. Excellent, excellent. So after subject matter jurisdiction, we're going to be talking about venue right here. Okay, thank you for your patience on that. Now underneath there, we're going to talk about traditional notions of fair play and substantial justice. So fair play and substantial justice. Okay. Oh, make sure to put that in there. There we go. There we go. Under supplemental jurisdiction, we're going to be talking about whether or not we have common nucleus of operative fact, which is technically where there's two particular claims or two particular aspects of the same claim share, say, the same transaction, conduct, or occurrence. Okay, and now underneath notice, we're going to be talking. Notice as service of process. We're going to be talking about personal notice, or sorry, notice meaning that, yeah, notice, and then we're talking about service of process, personal service, constructive service, and all the aspects requiring that. Okay, yeah, and then we want to make sure to talk about the California distinctions if we're going to be talking about the California jurisdiction stuff. And then now underneath venue. Venue is established by the domicile of the defendant, where, or I should say this, the first thing is where the substantial amount of the events took place, so substantial amount of events, and then domicile of defendant. If those don't help, you're going to be talking about the personal jurisdiction of the plaintiff, which as a fallback position. Now the choice of law. This is where we have the Erie doctrine. We have York, excuse me. We have Byrd, and then we have Hannah. And then now underneath pleadings, we're going to make sure to talk about that we have whether or not we have a valid complaint, grounds for the complaint up here, grounds for the complaint. Down here we have whether or not we have subject matter jurisdiction, so we have jurisdiction, and a prayer for relief. And okay, then make sure then amendment of the pleading. Talked about that. Okay, which we talked about the relation back test. Okay, under joinder, we're going to be talking about two types of joinder here: party joinder and joinder claims. Party joinder is basically two. Here we're going to talk about necessary, or excuse me, three: indispensable and let's see, necessary, indispensable, and you know what? I'm drawing a blank on this one. I'm going to put a little asterisk here. I'll fill that in later. Now under claims, we're talking about compulsory claims. Excuse me, counterclaims. We're talking about cross claims. And under counterclaims, we're talking about two types of counterclaims: compulsory counterclaims and permissive counterclaims. This is cross claims. So there we go. Okay, now Oh, bring this to this next page again. Oh, I mean that. I'll just have to copy and paste this to the other side. Here we go. Oh, should take that. There we go. Okay. Now, that pretty much, there's a little more we'll fill in here because, okay, we got the counterclaim, the cross claims. We'll fill in on another thing right there, but so that will be filled in later. Okay. Now, under disclosure discovery, I want to make sure to talk about under disclosure we have, okay, we got the disclosure of documents, parties, evidence likely to be used at trial. And then underneath that, we're going to be talking about scope of discovery. We're also going to be talking about privileged evidence. And then we're going to be talking about our discovery schedule order. And then if it does come to that, sanctions. And then down here under disposition without a trial, we'll be talking about dismissal, voluntary dismissal, judicial dismissal, or involuntary dismissal. Okay. And then now underneath this, we're going to be talking also about, let's see, I'm going to put a little asterisk here because I'm drawing a blank right now, but they'll fill it in. Excellent. Okay. Now, in trial, though, we're going to be talking about two particular things. Oh, let me come back here. There we go. Seventh Amendment. And I want to say judgment as a matter of law. I'll put a little asterisk by that one. And then under pretrial, we're going to be talking about renewed JMOL, which is actually called directed verdict. Up here, this is I'm sorry, judgment notwithstanding intended the verdict. Excuse me. JNOV, and this would be directed verdict up here. Then down here, we're going to be talking about motion for a new trial, motion to set aside judgment, and then motion to this would be conditional trial for concerning damages, which would be additor and remittitor. Okay. So I'm pretty sure that's, and I'm gonna leave a spot here if there's an additional one I'm gonna put in here for post trial. Under appeals, we got the doctrine of the final judgment rule, and under doctrine of former adjudication, we got res judicata, and don't forget collateral estoppel. Under res judicata, we got same. Okay. Valid final judgment on the merits. Now underneath here we got same parties, same claim, and let's see here. I think that's it. I'm gonna leave a little spot here for if there is one that pops up here. So valid final judgment on the merits, same party, same claim. I can't think of any. I know there's. I might be not thinking of one right off the top of my head right now. Okay, now we got another one here we're going to be talking about. Oh, thank you for your patience with me on that. Under collateral estoppel. Oh, sure we got. Oh, there we go. There we go. Perfect. Now this would be final judgment on the merits. This would be issue necessary for judgment, and this would be the see, final judgment on the merits. Put a little asterisk here, and then down here, we're see this would, okay, yeah, this would be the mutuality rule. But remember, we're also talking about whether or not parties who are strangers can actually come into the claim. So, oh, let's see. I think no. Let's see. I think that's. I think okay. And this would be probably where I'll put a bookmark right now. I make sure. Yep, because we have. Yeah, that's exactly what we'll do. And then we'll come back and finish up these guys on the next go around here, part 3. I thank you so much for hanging with me. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Again, thank you so much for tuning in, and God bless.